Good afternoon. It's time for your daily dose of stupid with Jose Maria Decastro. And we're going to thank Fish for this timestamp, 1855. Let's give it a whirl.
Judge Waldo, right? This is why we're going to get rid of Waldo, because he's prejudiced against me. He wants to hurt me, right? And he
Okay.
has absolute power when I'm in his courtroom.
I guess. I mean, he is subject to judicial review, i.e., you can appeal his decisions. You can seek a writ of mandamus, a writ of prohibition. There's some other writs you could seek. But yes, generally speaking, a judge has power in his courtroom to make orders. And those orders, they have to be consistent with the Constitution and with statutes and stare decisis, or else, once again, you can seek review, i.e. in a court of appeal. And you really shouldn't be picking at your skin there, Chillie. You know, drugs are hard on your skin and everything like that, but picking at it won't help.
Absolute power and qualified immunity. He can do anything.
It's not absolute power, and it's not qualified immunity. He has judicial immunity, which is complete. Judicial immunity is complete immunity for any judicial acts that he takes in his role as a judge. Now, if he performs some administerial function, like for the courts, like buying something or embezzling money from the court or whatever, he doesn't have judicial immunity for that. But any order he makes in his courtroom, it doesn't matter why he made it or whether or not he was corrupt or anything like that, he has judicial immunity. Now, that doesn't mean that he is going to escape punishment for it. It just means he cannot be sued civilly by you for it. You can seek review and get it and appeal it. You can report him to whatever governing authority, like the judges, I believe, are generally speaking, they're going to be responsible to the Supreme Court in their particular state. But you can make reports to the state bar or whatever reporting body handles it for your state, and they take it seriously. One of the fun things in California that you get as an attorney is whenever they are going to have a new judge, whenever the governor is going to appoint a new judge, they pick a group of people, members of the state bar in that area, and they send out notices to those people saying that, you know, such and such a person is going to be has been nominated or whatever to be a judge, and if you know that person, then please take this survey to see how you think they are as a judge. And I took one of those for a judge that I have a great deal of distaste for. I think this particular judge is a terrible judge, because some judges are better than others. You know, some judges have a more judicious nature where they make their rulings, where it feels like they make their rulings based solely on the facts and the law, and they don't let their personal opinions color it. This particular judge I had a very extreme distaste for. I've been in front of this particular judge, and yes, I am not mentioning the gender on purpose, but I was in front of this judge quite a number of times, and every time I walked away thinking that this judge has made up the judge's mind before all the facts were put out. The judge assumed the role of prosecuting attorney instead of maintaining the appearance of neutrality. And I watched a bunch of pro-pers argue in front of this particular judge. And man, this judge was just horrible to pro-per litigants. Horrible. Anyway, I contacted, I didn't contact. I responded to this particular notice by the state bar, And they also do it like if someone's going to go from being a judge to being a court of appeals judge. I responded to it, and I was actually contacted by the same bar asking me questions. Do you have more specifics about these particular things you're saying about this judge who wants to go up to become a court of appeals judge? And they took it very seriously. There is, the only real thing that judges have are the appearance of neutrality, the appearance of being judicious, and they guard it zealously. And I know that Chillie thinks this particular judge, Waldo, is against him. And it's most likely due to the judge not buying Chillie's bullshit, because the judge knows the law. And the judge is going to be looking at the facts and applying the actual law, not Chillie's stupid version of the law, to the facts. That's the way it works. So I'm sure that Chillie doesn't really like it, but, them's the facts.
Anything he wants to me. To get me out of the dungeon, you have to file a writ of habeas corpus, a petition for a writ of habeas corpus.
Well, I mean, it depends. Like you could file an appeal, depending on the particular state. You may have an automatic right of appeal. You don't necessarily have a petition for writ of habeas corpus is fun and everything, but you don't. I don't understand why people like Chillie think that federal courts are your only court that you can go to. If a state court makes a bad decision, why not appeal it to the Court of Appeals for that particular state? The federal courts aren't the only route that you can take to get justice. So it's just weird. I just don't know why you would do the writ of habeas corpus. Anyway.
A petition for a writ of habeas corpus is 30 pages. 30 pages. It's
30 pages.
Month of work.
30 pages in a month of work. This is from uscourts.gov. This is their petition for relief from a conviction or sentence by a person in state custody. And as you can see, it is 16 pages long. And I don't know if this would take Chillie 30 days of work to do. They're not really asking you for the law. They're not looking for some complex legal argument. That you got to say, like, okay, so these are the facts. This is what the judge ruled. This is what the judge should have ruled. And that's really all you have to say. The judge wrongly denied my motion to suppress. Boom, or something like that. But anyway, yeah, it's not 30 pages. And that should not take you a month to do. The first page is just instructions. So really it's only 15 pages. So who knows?
A month. And the judge can just do it to me.
Well, yeah, but I don't know how much judges think about their potential career path. But if a judge gets overturned all the time, that's something that might affect the judge's ability to move up to become a Court of Appeals judge. So, it's something to think about. And, every judge is going to have their own motivation, but I'm sure this particular judge that Chillie's in front of sees a lot of people. Judges, I don't think, have a lot of free time, and I don't think they really establish much of a personal feeling towards the litigants that are in front of them, the defendants, the whatever. I do think that there is a little bit too much chumminess between judges and public defenders and district attorneys, because they're always together and they they're literally always, it's like every day the judge sees these particular people. And, I feel like as an external person, not a public defender coming in, sometimes I feel, well, in the few times that I've been a criminal defense attorney, I did feel like there was a bit of a hometown thing going on. I felt like I was getting hometowned a little bit, but it is what it is. I just don't, but I don't think that judges really have the time or concern to really get. I don't think they just really care about any particular defendant who's in front of them, unless that defendant starts causing problems. Unless, like, squeaky wheel gets the grease. I mean, if you're just a real asshole, if you're a sovereign citizen and you go out of your way to be a sovereign citizen, well, then the judge might start taking notice of you and start building up towards sanctions or something along those lines.
1951, Tenney, Tenney versus Brandhoff, Brandhove. Judges are immune.
Well, if he had read Tenney versus Brandhoff, he would realize it has nothing to do with judicial immunity. You can see I'm looking up judicial immunity. It has nothing to do with it. It has nothing to do with judicial. It has nothing to do with judges. So there's a dissenting opinion, there is another dissenting opinion, and the action was dismissed by the district judge. This is about legislative immunity. This is qualified immunity that was given to legislatures. So that's what Tenney versus Brandhoff was about. Now, as far as judicial immunity is concerned, I'm not a constitutional scholar. And, I haven't spent 20 years researching this, but I'm reasonably sure that the first time it kind of came up was in 1872 in Bradley versus Fisher, where the Supreme Court, the United States Supreme Court in 1872 decided that judicial immunity was based in English common law and it applies to federal judges. So, for whatever they do in their official capacity as a judge, for whatever orders they make as a judge, rulings they make as a judge, they have complete immunity, and it's gone on from there. So, I mean, there's hundreds probably of cases about judicial immunity, and it doesn't matter. It doesn't matter why they made their decision. It doesn't matter how terrible of a judge they are or corrupt they are. They have complete judicial immunity for the decisions that they make. Now, that only applies to civil suits against them. They may still be punished for what they've done. You just can't sue them for it. So everybody always thinks that like qualified immunity means that police get away scot-free. Well, except for those police that have, criminal charges brought against them. Except for those police that are fired because of their actions by the police department. Qualified immunity doesn't protect the police from that. Judicial immunity doesn't protect judges from actions by the state bar, by the Supreme Court, by whoever it is that can sanction them. So there you go. Well, anyway, I guess I'm done. I could go on, but why bother? It's just another idiot being an idiot day for Jose Maria Decastro and his little pet herpes right there. Thanks for watching. Have a great day.